Welcome to the lesson on Subject Access Requests, SARs, under the General Data Protection Regulation, GDPR. As usual, the learning materials for this topic can be found in the description below the video in order of appearance. Under Article 13.2 of the GDPR, controllers must notify data subjects of their right to access their personal data. An online order involves personal data, for example names, addresses, payment details. So a Subject Access Request, SAR, clearly falls within this framework. The controller must first determine whether personal data has been processed. Regardless of outcome, the data subject must be informed. Where processing is confirmed, which is inevitable in the case of online orders, including minors' data, the controller must provide all disclosures required under Article 15 GDPR, for example, purposes of processing, categories of data, recipients, retention period, and rights of the individual. SARs may be submitted through any channel, including email, social media, or direct messages. Controllers must respond without undue delay and within 1 month. Articles 12.3 and 15 to 22 GDPR. This includes cases where the request cannot be met, in which case the controller must explain why and inform the individual of redress avenues, for example, complaints to a supervisory authority or judicial review. SAR responses must be provided free of charge after a reasonable search. A reasonable fee may only be charged or a request refused if it is manifestly unfounded or excessive with the burden of proof on the controller. If refused, the individual must be informed of the reasons and their rights to complain or litigate. We will now turn to real-life case examples. 1. ICO. Investigation into Data Broking Practices, 2020. The ICO, UK, found credit reference agencies had failed to provide complete and clear SAR responses, forcing Experian to overhaul its transparency practices. 2. ICO Enforcement Notice, May 2019. The ICO, UK, ordered Her Majesty's Revenue and Customs, HMRC, to delete millions of biometric voice records after consent and transparency failures, including difficulties handling SARs. 3. CNPD Decision, July 2021. The Luxembourg's Data Protection Authority, CNPD, fined Amazon 7 from 47 million, citing inadequate transparency and SAR responses among systemic GDPR failures. 4. Austrian DPA Decision, 2019. Austrian Post was fined for political profiling without disclosure, with complaints highlighting inadequate SAR responses. Let us now compare the regime to the UK GDPR post-Brexit. The UK GDPR and the Data Protection Act 2018 preserve most SAR rules, but with some nuanced differences. Time frame is still 1 month, extendable by 2 months for complex requests. ICO. Guidance emphasizes controllers must explain extensions promptly. Identity verification. ICO guidance. 2022 states that controllers may request proof of identity where necessary, though they must avoid creating unreasonable barriers. Fees. SARs are generally free, but a reasonable fee may be charged for manifestly unfounded or excessive requests, consistent with EU GDPR. With respect to manifestly unfounded or excessive SARs, UK regulators stress context. For example, motive alone, such as, among other things, litigation, is insufficient to refuse, unless clearly abusive. For more details, see Harrison and Cameron, decided in 2024. Exemptions. The UK allows broader exemptions under the Data Protection Act 2018, for example, crime prevention, management forecasts or negotiations, which can narrow SAR rights compared to EU jurisdictions. Overall, while substantive rights remain aligned, UK GDPR practice offers controllers slightly more leeway via exemptions and regulatory discretion, whereas the EU supervisory authorities have been stricter in enforcement. We hope this lecture was helpful to you. If you wish to learn more about the GDPR, take a look at our dedicated videos. Thank you for your interest in this topic, and we are looking forward to seeing you again soon.